This week on Act Out, it's all about the courts. First up, a big step forward in the fight against Monsanto and glyphosate, as hundreds of cases get the green light to take this massive poison peddling corporation to court. Next up, water protectors Red Fawn Fallis and Michael Littlefeather Giron have received harsh sentences for their efforts to protect water, land, and people at Standing Rock in 2016. We sit down with the Water Protector Legal Collective to discuss updates on these cases, as well as the hundreds of remaining cases. From tweets to marching in the streets, this is Act Out. Welcome to Act Out. I'm Eleanor Goldfield, and this is your tipping point. I want to start off today with some good news, because, I think we all need it. Last Tuesday, a federal U.S. district judge in San Francisco ruled that hundreds of cancer cases against Monsanto can proceed to trial. After years of litigation and weeks of hearings, folks seeking to sue Monsanto over their cancer-causing products will be able to take their stories to a jury. The decision came a day after Dwayne Johnson became the first person to ever get Monsanto to trial over allegations that the company has concealed findings that glyphosate, the active ingredient in the company's popular weed killer Roundup, causes cancer. Johnson is now 46 years old and at 42 was diagnosed with non-Hodgkin lymphoma after working for years as a groundskeeper, where his duties included direct application of Roundup and Ranger Pro, Monsanto products that contain glyphosate. In the opening statements, Johnson's lawyers showed images of lesions and rashes that appeared on Johnson's skin during his employment as a groundskeeper. The trial is a landmark, not only because Johnson is the first to take Monsanto to trial, but also because the judge has allowed scientific arguments to be admitted into the proceedings. And with that, lawyers also brought to light internal corporate documents that sought to cover up and obstruct scientific findings that fly in the face of Monsanto's long-standing claim that their herbicide is totally safe. Johnson is 46 years old, and he will die. Timothy Litzenberg, one of Johnson's lawyers, told The Guardian on the first day of trial that regardless of the outcome, so much of what Monsanto has worked to keep secret is coming out. While it's too late to save Johnson's life, and perhaps many of the hundreds that are now going to trial against Monsanto, this step is an important one. It's a step closer to banning glyphosate and holding Monsanto, now owned by Bayer, accountable for their literal crimes against humanity and, indeed, the planet. So this is good news because it shows what people are capable of when they refuse to give up. It is a victory in the midst of a sea of losses. And still, we should take that time to recognize it and to let it inspire us to keep fighting. Moving on from Monsanto in court, let's now shift to water protectors in court. Last week, Red Fawn Fallis was sentenced to 4 years and 9 months in prison for allegedly shooting at officers in Standing Rock in October 2016. Officers tackled Red Fawn during a peaceful protest, pinning her on the ground face down. They then claimed that she fired 3 shots from a revolver underneath her stomach. No one was injured. Later that year, it came to light that the gun in question belonged to FBI informant Heath Harmon, who had infiltrated the camps and gotten close to Red Fawn. In January of this year, Red Fawn accepted a plea deal which kept her from a mandatory 10-year minimum sentence. Now, for those of you familiar with COINTELPRO, or perhaps even such cases as Huey P. Newton's, the co-founder of the Black Panther Party, this might all sound sickly and eerily familiar. In Newton's case, he was sentenced to prison after being found guilty of voluntary manslaughter of a police officer in Oakland in 1968. During the incident that led to his conviction, Newton himself was shot with a police revolver. After serving 22 months in prison, Newton was released in 1970 after the conviction was reversed. There is much that history can show us with regards to the empire's disdain for those seeking justice and human rights, especially if they're Black, brown, or indigenous. In June, Michael Littlefeather Giron was sentenced to 36 months in a federal prison, the first water protector to be sentenced to federal prison for his participation in the DAPL protests. Littlefeather has already been in jail for 15 months, time that will count towards those 36 months. So he now faces 11 months in a maximum security federal prison in West Virginia. In the final days at camp in 2016, law enforcement conducted violent raids, destroying property and expelling protectors. Littlefeather was allegedly identified as one of the individuals who set fires that obstructed law enforcement in the course of their raids. Earlier this year, Littlefeather took a non-cooperating plea deal in order to avoid trial, accepting the charge of aiding a, quote, civil disorder in exchange for the prosecution agreeing to drop the charge of use of fire to commit a federal felony. Last Friday, the day after Red Fawn's sentencing, we sat down with Terry Janis, the executive director of the Water Protector Legal Collective, and Leola Cowboy, legal aide and wife of Littlefeather, for the latest on these cases against water protectors and others. Take a look. Red Fawn was sentenced to 57 months in jail. So will the time that Red Fawn has already served be considered as part of that 57 months?
Yeah, it will, and they'll break it out based upon the time that she served in the jails and the prisons, and then the much more limited amount of time that she served in a halfway house. So she was initially a prison, I think, in October 2016. So about 18 months of that time will be credited as time served.
Gotcha. And shifting to Littlefeather, he was transferred to a federal prison in July. Could you talk about that move and the legal precedent for that based on his charges?
Sure. So Littlefeather was federally charged, and like we said, there are a couple of other charges, right? There's 7, 6 have moved forward. So this charge of civil disorder, and originally had that and use of fire to commit a federal offense. And he took a non-cooperative plea, and that was to civil disorder. His sentencing was on May 30th of this year. So the reason why he's going to federal prison is because of this. It's a federal charge of civil disorder. Civil disorder is a federal charge. Like the other federal defendants, every single one of them has that civil disorder charge. So currently he is in Hazleton USP. That's a maximum security penitentiary. And he was in Burleigh County for a week. It took 5 weeks, 4 jails, for him to get into the BOP system. So he entered BOP on July 2nd, and that was in the transferring center being processed. And on July 9th, that's when he entered into Hazleton. And like I said, that's maximum security prison. We were, as his legal defense team and the judge, when we were in sentencing on May 30th, we were talking about his guidelines and preparing for him to go into medium security. And up until July 2nd, that's when we were aware of the news that he's actually going into a maximum security prison.
Was any reason given as to why that shift from medium to maximum occurred?
No, we don't know. We have no idea, to be totally honest. And I've reached out to the lawyers, and they're currently looking into this right now. But it's not like we can be like, oh, hey, you made a mistake. Can you change it? Can you change things now? I don't know how the federal system works. I doubt it's going to be an easy fix. It's going to take a lot of work for us to get this figured out.
And there's no legal requirement to let the legal team know about this kind of switch then?
Apparently not, because he's in there.
And as I understand it, there are other federal cases that are still open, and also state cases. Could you talk a little bit about that differentiation with regards to the water protectors?
Yeah, there are 7 individuals, all indigenous, who are charged with federal charges, and 835 state charges. The state charges, of course, under state jurisdiction and a range of different charges. What's distinct about the federal charges, and Lola started talking about that, is the underlying charge is based upon a charge of civil disorder, which at its core, in order for it to be a federal charge, has to tie to an interference with interstate commerce. And so that, and then federal legislation establishes the civil disorder charge based upon this kind of interesting history of incidents where there might be a protest or a civil disorder in which a fire is set, firemen go to put out that fire, and in some situations they might have been obstructed or hampered from doing their job of putting out the fire. So the civil disorder charge in particular was designed to apply directly to that, often in labor movements or civil rights movements or other things like that. But the recent application has primarily focused on indigenous peoples, activists, protest movements, and African American activist protest movements. And it's a unique sort of utilization so that, you know, even though the underlying sort of issue of a fire or fighting a fire or something like that is not relevant, that is one of the key federal criminal charges that are brought against indigenous peoples. And in this particular situation, it's also interesting and unique that all of the people that were brought on federal charges were indigenous.
And with regards to those charges, we've seen across the country recently, particularly since Standing Rock, these sort of more extreme charges, particularly based on when it comes to things like infrastructure. Was that something that you also saw in these cases, that the charges were more extreme because it specifically had to do with quote unquote infrastructure, the oil pipeline?
Well, what's interesting about that is a lot of those, infrastructure-related bills and legislation are passing at the state level. And I don't have the exact numbers of how many states have moved bills forward along those lines, but that process is a reaction to Standing Rock. And in some states, it is a directly stated reaction. We don't want the Standing Rock in Wyoming. We don't want a Standing Rock someplace else. And in Wyoming, for example, that bill did not pass, but in other places it has. And what they've done in responding to that and reacting to that is an overly harsh and negative response to the simple American constitutional right of protest and dissent. A recent bill was introduced in Congress, I believe just this week, called the Antifa mask bill, right? And bringing forward or proposing extreme numbers of years for something that is a relatively simple and straightforward act of putting a covering on your mouth. But what it really goes to, and you know, some of the commentary within the papers this week have been on that bill is a campaign-related sort of effort to really, you know, stake out a position that helps them in the primaries. But regardless of that, the numbers of bills that are occurring both at the federal and state level should be of great concern to American citizens.
Because it's really about criminalizing dissent and the ability to say no to something like a dirty energy project, such as the Dakota Access Pipeline.
It also clarifies the connection between corporate America and the governments of this country. The history of this critical infrastructure bill comes out of a nonprofit organization that is significantly funded by the extraction industry.
So with regards to the plea deals, talk about how those, if you can, talk about how those were used. What's at stake for people who don't accept a plea deal? And what does accepting that guilty plea mean for anything in the future of these defendants?
Well, let me talk about the broad thing, and then you can add to that. So from our perspective, the critical piece is in in the work that we do at Water Protector Legal Collective is creating resource and infrastructure that makes sure that every water protector that is charged with either a state or a federal crime has available to them excellent legal representation. That individual water protector has complete free will. That individual water protector is carrying their protest at Standing Rock to the courthouse in the way that they choose to. And they will decide what their life needs are. And so whether an individual decides that they want to push it all the way to a jury trial or take a plea agreement or make some sort of arrangement, that is that individual water protector's choice. What we do is make sure that the attorneys that we make available to them are the most highly qualified and talented attorneys that we can find, and that we make sure that they communicate with on a consistent basis as much as possible, so that there's some clarity that that water protector is engaging with their attorney, making their wishes and desires and decisions clearly known, and that whenever they move together with a legal strategy, that it is above board and clearly communicated in the best strategy that they can engage.
So what's at stake for them? Their livelihood, their jobs, their children, their future, convictions, money, worries, stress. There's so much at stake for everybody, federal or state. They're dealing with a lot of things. People have lost jobs because they have charges here. People can't get jobs because they have charges here. So it's pretty extreme what's going on here. It's unfortunate, but this is what state and federal governments will do, right? To keep us, to silence us, to criminalize us, to dehumanize us. And we're protecting our land. We're protecting what our obligations are to our ancestors. And we don't have, all we have are our prayers. All we have is each other. And we're being criminalized for protecting what we're supposed to protect. It's outrageous, unfortunately, but we understand what's at stake too. And we definitely do the best we can to give the water protectors what they need.
It's also important to note that at the federal level, each of the water protectors that has negotiated a plea agreement has made sure that it is a non-cooperating plea agreement. Each one of them has been very deliberate about not doing anything that implicates or makes more difficult the charges of other water protectors, whether it's at the federal level or the state level.
So I believe the strategy for agencies are to have mass arrests, and that's one of their strategies, right? To silence us, to keep us from protecting, from us engaging in protests. We don't call them protests. We're getting together and protecting our community. We're protecting our future. We're protecting our children, our grandchildren, those unborn. We're protecting the animals. There's so much to protect. And these agencies don't see that.
You know, we each one of us came to this job for different reasons. Lola came to this job and others because of their participation in Standing Rock. And I came to it not so much as a participant in those protests, but as a member of the Oglala Lakota Nation and a participant in Indigenous rights movements for my entire legal career since 1989. And one of the things that is absolutely clear here is that what happened at Standing Rock is standing on the shoulders of generations and generations of Indigenous peoples that have stood up and protected their rights. And they may be called by many different names, the American Indian movement, different military and cultural battles that have occurred throughout the 300 years of this effort. These movement activities have always been led by individual indigenous peoples that have stepped up in a variety of different ways. But some of our more successful efforts have been started by individuals that led to a recognition of our treaty rights, whether it's in the Northwest on fishing, or in Minnesota and Wisconsin on fishing and hunting, and the fact that our treaties have clearly established mechanisms by which we retain authority and right over those lands that we have given up in return for reserved lands on what are called reservations. And that is part of what has been at stake here. The lands where indigenous peoples and non-indigenous supporters are protesting is a part of the treaty that has been reserved for Oglala and Lakota people, and Dakota and Nakota. And that land has long been recognized and protected by Standing Rock and other indigenous peoples that have treaty rights to those lands. And so this is a completely consistent movement activity, protection activity that has had many examples of success over the last several decades in the modern kind of nature of movement work and movement activity with indigenous peoples in this country.
Any information that you can add with regards to updates on trials and updates on water protectors that you're working with?
Yeah, so we have some state cases remaining, 26, and we actually have outstanding warrants, unfortunately, and we're actively trying to help those who have warrants, and these are state cases. And we've been doing a lot of reaching out, networking, trying to get these warrants taken care of. So hopefully maybe this interview will help. Whoever has an interview, please call us. We definitely want to work with whoever does, because we have the resources available right now. And that's a limited time offer, unfortunately. We're not going to be here forever. But we have the resources and the capacity to deal with these things right now. So next week for the federal cases, we have Dion Ortiz going to, this is on the 17th at 1:30 here in Bismarck, going to change his plea. And then for Dion, we also have him moving forward in his sentencing, which is October 22nd. From my understanding, Radler, which is Michael Marcus, he has his sentencing September 27th. I believe that's the date. And then we have 2 others preparing for trial. So that's what we have so far. Right now we have 2 political prisoners. We have Little Feather and Red Fawn. And they need support. They need support. They need people to write to them. They need people to send them books. They need people to send them money and stand in solidarity with them.
One of the things that we want to encourage is that the individuals that are going to spend some time in jail, the level of support that we need to give them, there just can't be enough. And their families and community members and support people within their communities and across the country are doing a great job organizing websites where they can link on, provide some support, whether it's a letter or some money for the commissary or some other way of just showing solidarity and support. But there cannot be enough of that. These guys, these men and women really need us to continue to stay with them. And they know that as they do their time, that they are following through on the commitment that they made at Standing Rock, that they are continuing to stand in protest and protection of the earth and the water, and that every day that they do in prison is a continuation of that protest and a continuation of that support. And our communities, us as communities that are free within our society, owe them a debt of obligation, and any support that we can give them is really important. The second thing I want to kind of bring out in closing is of the 835 cases on the state level, 345 have been dismissed, 33 have been acquitted, and 173 pretrial diversions. There's only 136 plea agreements and only 17 convictions. What this tells us is that the protests and the arrests that happen and the way the police, whether it's the local police or the police that came from Texas or Minnesota or wherever they came from, the police that came from the federal government and the corporate security firms like Tiger Swan and others that engaged, and the way they got together in a significant overreaction of their response to it, resulted in arrests that should never have occurred. They should never have occurred. They were thrown out of court at the state level because even though there is tension in this community, there is also a constructive and positive rule of law. We have engaged this court system in a full-on legal fight, and they have engaged us in a full-on legal fight. But there is rule of law here in Mandan, North Dakota. And it is because of the integrity of the rule of law and the way the courts have upheld that we see the results that we see today. It's not so much that we were better than them. These arrests should have never been made.
To learn more about the Water Protector Legal Collective, visit waterprotectorlegal.org. And that will do it for this week's Dose of Dissent. Thank you so much for watching. Please spread and share this with all of your friends, foes, and people that you don't know. Again, check out the last slide and the show description to find the sites that I've mentioned in this week's show, and for interim updates as well as posted videos, images, and articles. Visit us on social media. And also to those who have donated to help us keep going, thank you so much. Please keep spreading the word in order to ensure our ability to keep bringing you this news. From the Devil's Den, good night and act out. And real quick, to keep independent, non-corporatized media like this show going, visit patreon.com/actout.
I can hear the boots are stomping. Come on, boys, let's get some rocks to throw. I can't stand to hear my father cry anymore. Time we left one of you motherfuckers dead in the road. We've been backing up inch by inch. We got nowhere else to go. It's been too many years since you pushed inside my show.